Hi, I'm Joe Ford. I'm an Associate Professor here at the ANU College of Law. And this is Torts in the age of the coronavirus. The first, perhaps the most obvious, is around workplaces and the relationships between employers and employees in terms of the duty of care that exists to provide a safe working environment. What it raises is a perennial issue in the law of torts and in our society generally, which is to what extent should we take responsibility for ourselves, especially in the face of more obvious risks, and to what extent can we pin that responsibility on someone else, in this case the employer, to warn us to close physical spaces and so on. And I think in the immediate term that's the most obvious torts issue that arises, is around that duty of care in the workplace. A second more thematic issue revolves around issues of the calculations we make of risk versus social utility. So here I'm thinking of the decisions that people will be needing to make or have already made in hospital environments, for example, triaging patients and deciding how to allocate limited time and resources, and the defenses that they might be able to use to any allegation that, for example, they didn't provide reasonable care in the circumstances. So the law of torts has functions and facility to take into account decisions that were taken in a certain context because of the social usefulness of the activity, even if it was risk-taking. So if we think, for example, about clinical trials and all the torts issues that you might associate with clinical trials in terms of informed consent or what have you. But if we're in an emergency pandemic environment and we're speeding through certain clinical trials, there might be calculations or risk-taking decisions made which in any normal circumstance might be seen as unreasonable, but which the contextual circumstance of a pandemic transforms into something socially useful and therefore reasonable and therefore not necessarily negligent. The third thing, I guess, is also kind of a little bit high level, but it's related, which is government decision making. The line between what is a policy decision around allocation of resources, for example, and what is a decision that is justiciable, that a judge can decide as a question of law. So when the government, in Australia, the federal government or state governments, territory governments, are making decisions as they are now on a day-to-day basis about where to allocate resources, where to allocate priority, who wins and who loses, for example, in the allocation of resources. One of the issues for the law of negligence is the limited extent to which some of those decisions are really properly the subject of what judges can do in particular claims, in particular cases. Are they justiciable, or are they high-level policy decisions that don't fall for discussion in the law of negligence about what was a reasonable decision to take? The fourth issue is that when I think, as negligence lawyers do, torts lawyers do, about loss and harm, by far the most significant in scale terms of kinds of loss or harm in this crisis is going to be of an economic nature, and of a pure economic nature, in the sense that it's not necessarily connected to any physical injury to an individual, but the consequential economic loss that they suffer as a result of other people's decisions and other people's behaviours. And the law of torts is still exploring, the law of negligence is still exploring the extent to which we owe duties to others to avoid actions or omissions that cause them purely economic loss.